Hello, everyone. Welcome to our next lecture, Dred Scott v. Sandford. I thought this time we'd switch it up a little bit and just look through the case together rather than go through slides. You should have this in your course packet. As you'll see, there's some important parts. This case, I think, is over 200 pages long, so I edited it down to about 20 pages and then highlighted some of the key areas that we'll talk about today. So let's jump into it by first looking at the background and the historical context in which this case is situated. So slavery. Slavery is at the heart of this case. The rights of African Americans within this country, in the United States. And so it touches on a lot of sensitive topics, some topics that are still relevant and discussed today from a variety of perspectives, but for our purposes here, we are going to look at the historical context regarding the institution of slavery. So slavery was introduced to the English colonies sometime in the early 17th century. Indentured servitude was also common, where individuals had to basically work for their fare to get over to the New World. So they have to pay off that debt to secure the passage. And then over time, just the labor for slaves or servants or general workforce was increasing as plantations were established. Agriculture was taking off, especially in the southern states and along the East Coast. And so that led to the growth of what we're going to call chattel slavery. So chattel is a concept in law that basically means personal property. There's a difference between real property, that would be land, houses, and chattel or personal property. So that could be anything from livestock to tools to even effects like your books or dishes or table, furniture, things of that nature. And so with regard to the laws regarding slavery, it was protected as property rights. So people, which I hope is not news, but people at one point in time were considered property. You could legally buy and sell, trade people as slaves. So that didn't only pertain to the English colonies. That didn't only pertain to people of African descent. But with that being said, that's the sort of historical context that this case is situated in. So you can hopefully see here, if you can follow my mouse, the case was, or the opinion I should say, was rendered in 1857. But the conflicts that really led up to this case took place long before 1857. It just so happens that this was a very contentious point in our nation's history. So regarding the legal framework, going back to the institution of slavery and start situating your mind with what was going on in the United States around this time, and especially in the decades leading up to this time, the colonies developed into states, of course, with the ratification of the Constitution, and so then there were certain laws and codes that were maintained and enacted to regulate slavery. So these slave codes varied by state, and they controlled various aspects of an individual's lives, including restrictions on their movement, where they could travel to, how they could travel, with whom they could travel with, their education, and their marriage as well. Oftentimes, marriage between slaves was not recognized, and so a lot of the benefits and protections that the law would afford other married couples were not given to slaves that were married. So generally speaking, just sort of across the board, the legal system reinforced the institution of slavery, again, based on the premise that slaves were property, that it was a property right being protected. And if we know anything about concept of foundations of law so far, is that property is a huge fundamental concept within the law. So where and how far and to what extent the government will protect property rights is usually a very great point of debate and contention. Like we saw in the last case, Marbury v. Madison, that was the whole premise, right? Mr. Marbury had a vested legal right. In a lot of ways, it was like a property right in that it belonged to him. He had ownership of that right. And so then the question became, of course, for the court, what are we going to do about it? We're more or less situated in a similar context here. States, of course, are divided between whether they're going to reinforce and protect property rights, chattel slavery, or other states that are starting to grant more freedoms to certain people, particularly of African descent, within their jurisdiction. So, for example, there were some states that gave men the right to vote at the time the United States Constitution was ratified. This will be a really important point that we'll get into within the opinion and within the dissenting opinion. But all that to be said, there is a huge culmination of competing opinions on what is best for our country. Roughly half the states are saying slavery is a way of life. It's an institution, a property right that needs to be protected to support our businesses, our plantations, our estates. Other states are arguing that these people, slaves, African Americans, other races that have come to the United States as property, or their descendants at this point, deserve the full protection of the law. Maybe not to quite the same extent as people of European descent or other rich or well-connected people, but nevertheless, there's that general conflict going on. So slavery is becoming a central issue in the growing divide between the northern and southern states. The northern states gradually abolished slavery during the late 18th and 19th centuries, while the southern states are defending the institution of chattel slavery. And so then the debate over the expansion of slavery into the newly acquired territories is really the context in which this case, Dred Scott v. Sandford, is situated. So let's take a pause there, and let me see if I can flip over this way. Hopefully you can see that. We'll see. Missouri Compromise. Missouri Compromise is the piece of legislation that is promulgated by Congress and is really the backdrop for this case. We've kind of set the scene, right? We know if you've had other history classes, American history classes that have gotten to the founding of America, and then of course the early part of the 1800s, pre-Civil War, pre-antebellum, we're thinking about what is going on in the United States. So the Missouri Compromise is law promulgated by Congress to start reconciling this tension between states that are pro-slavery and states that are anti-slavery. So these colonies or colonists have now become states. People are moving westward, right? More land, better opportunity, more dangerous, of course. If you've ever studied the Comanches or any kind of tribes of Texas, that's one of my passion projects on the side. That'd be an incredible course to teach. I don't know if it's necessarily applicable, but people are moving westward, so suffice it to say. So the United States is expanding west. Territory is, of course, purchased through the Louisiana Purchase. And so now the United States, the federal government has to start figuring out, well, what are we going to do about these slave states and these free states? It's impacting political representations, impacting legislative decisions. If you're counting slaves as people, and that means you get more say in the House of Representatives, all that sort of contention is building up right now. So the Missouri Compromise basically says, you know what, look, we're going to admit Missouri as a state, and Missouri is going to be a slave state. But to balance things the best the United States can, we're also going to admit Maine as a free state. So the whole principle here right now is just balance. On balance, how do we keep the United States from breaking in half? Well, we're going to have this compromise, this Missouri Compromise. So this line right here, 36 degree, 30 minute, 3630 parallel, was established for the dividing line between the states. So if you're going north of this line, this is a very generalized claim, but it'll work for the purposes of our case. If you're going north of this line, then you're in free country. You're in free territory. There's no slavery. If you're south, then slavery is recognized and protected. So it arguably eased some of the tensions building up in the United States, but of course it had long-term implications and complications that we don't necessarily need to get into now. But for our purposes, and I may refer back to this map as we go on through the case, if you're going north of this line, freedom, no slavery. South of the line, then slavery is recognized and protected accordingly. So let's start jumping into the case now. Set the scene. Slavery has been a big issue. It's continuing to build up and become more contentious throughout the decades leading up, of course, to the Civil War. And so now this case is almost perfectly timed to be in the middle of this storm, this war, right? That's building up, the tension that's being developed on each side. So who are our players? Dred Scott here is a former slave, who basically sued for his freedom against his then current owner, his current master, John Sandford. So kind of funny story here. His name is actually Sandford, and the clerk, when the case was admitted to the court, basically threw in a D. So typos are important. They could, in fact, go down in history. So just kind of word of the wise for the writers out there, how important it is to proofread the work. So moving back on, Dred Scott. So he basically bounces around from several different owners. He was an enslaved African-American man born in possibly 1799, likely in Virginia. So then Scott was owned by Peter Blow, a Missouri resident, who later sold him to John Emerson, an Army surgeon. Dr. Emerson, took Scott to various locations, including free states, right above, north of that 3630 parallel line, and on various trips or excursions or business, whatever he had going on. And so in these territories, slavery was, of course, prohibited, like we just discussed. So upon Emerson's death, Mr. Scott sought legal action for his freedom, claiming that his time in the free territories made him legally free. There's this concept that once free, always free. So it's almost like he got north of that line, and that was enough to declare his status as a freeman, not as a slave anymore. He may have been brought into those territories as a slave, but by virtue of crossing over into those lines where the states or the territories do not recognize and acknowledge slavery, then he became a free man. That was his argument. So then his adversary, his master here, Mr. Sandford, and I may say Stanford, same dude. So Sandford argued that Scott remained a slave and had no legal standing to sue for his freedom. So legal standing. Let's actually just park that real quick. Just throw it out in the air. No, it's standing right there. We'll get back to it here in a second. So in the legal case, Dred Scott filed a lawsuit against John Sandford in 1846. So 11 years plus before the court actually rendered its final decision. In a Missouri state court. So it started out in state court, claiming that he should be granted freedom based on his residence in free territories. Once free, always free. The case eventually made its way up to the United States Supreme Court, where it had far-reaching implications for the status of enslaved individuals and the expansion of slavery. Okay, so perfect example of sort of the microcosm of the case, but by virtue of the holding within this case, it would spill out and over to all sorts of other issues that would be brought up under this same or similar issue. Namely, whether African Americans or any former slaves that descended from African Americans could have legal standing in the United States. So, legal standing, what does that mean? It's a procedural concept that means you have a right to be in court. Whatever was your complaint or your grievance, it belongs to you, and so therefore you have the ability to stand before the court. To have legal standing means that you can actually have your day in court. So kind of a hyperbolic example here. What was the big case that happened not too long ago? The two celebrities. There's a defamation case. Johnny Depp and Amber something maybe. I should think of these analogies, examples beforehand. But anyway, those two people, right? They're suing each other, right? And they're saying, you did this. Well, no, you did this. All this kind of stuff. I can't go in there and say that those claims actually belong to me, right? I had nothing to do with that. You had nothing to do with that. Maybe. I should hope not, but maybe you did. I don't know. The principle, though, is that claim doesn't belong to me. I have no legal standing in which to appear before the court. And so if I don't have any legal standing, then I have no reason to be there. Bring it back home. Let's say that I have two neighbors that are fighting over a fence. And one neighbor is saying, this fence is on my property. And the other neighbor is saying, no, it's not. It's on my property, or whatever. And one of them wants to tear it down, whatever it may be. I can't, as some removed person, go into that dispute. I have nothing to show for it. I have no claim. There's no injury done to me. So, kind of bringing that back, the central issue in this case is whether Mr. Scott, as an enslaved person, and of course he's going to argue that no, he's a free man, has the right to sue for his freedom in federal court. So the question here that we can dive into, the issue before the case, is twofold here. And again, I love when the opinions will tee this up for us. But the two leading questions presented by the record: one, had the circuit court, the inferior court, the lower court of the United States jurisdiction to hear and determine the case between these parties? So could they even hear it, right? Was it even proper to be before them? And two, if it had jurisdiction, is the judgment is given erroneous or not? So like I said, this case was something like 200 pages long. I by no means expect you to read this entire case. It has a lot of interesting analysis. It has some really sad analysis on the way that these men viewed other men and other people, entire races of people. For our purposes here, when we're situated in the context of slavery is a hotly debated issue, and there are in fact slaves in some parts of the United States and no slaves in other parts of the United States, there is this question that arises of whether an enslaved person has legal standing or right to bring a lawsuit in federal court. We may gloss over that now. It may not seem like a issue. It may just seem like an immediate, duh, right? Like it's a persons are injured. Okay, so yes, court is the right legal remedy, right? Where else are you going to turn to, essentially? If you want law and order to be done, the court is the place to do it. We saw that in Marbury v. Madison, where if there are in fact rights given to people under the law, then remedies must be afforded to them. And that is the whole premise of civil government, is to protect those legal rights. So if someone like Mr. Scott, a enslaved person who's suing for his freedom, basically filing a lawsuit against his master to say, you don't own me. I am my own man. I am a free man now. The question comes up of whether he can actually do that, right? Whether he can actually come to the court. To use sort of a crass analogy here, the way that this would have been seen, and if you read through a lot of this analysis, you'll see that slaves were seen as, again, chattel, as property. So it'd almost be like asking, well, my horse had an issue with me, and does a horse have a right to come into the court? And that should grip us, right? That should hurt something inside us. I would argue that's part of the imago Dei, that we all are created in the image of God. And so why would we think that these people are property, right? That don't have a right to stand before the court? Well, the court was situated in this context, right? It was situated in this historical period where slaves were, in fact, property. So do property, does chattel have the legal right to stand before the court? That's the issue. That is quite literally the issue that the court is having to address. So in whatever it was, 100 pages for the majority opinion, and I took out a lot of the concurring opinions, and then there's 2 judges that dissented, which means they disagreed and stated their reasons for disagreeing. The court analyzes this. They think through whether, again, property has a legal right to stand before the court. So, significance of the question, going back to kind of the microcosm issue here, the question was significant because if Mr. Scott was not recognized as a person, quite literally a human being, with the ability to sue, his claim for freedom would be denied because the court could not constitutionally hear the case. There would be a want of jurisdiction, which means the court had no way to resolve this dispute. Perhaps seems like a cop-out to our modern notions of justice and fairness and equality. But that was before the court. If the Constitution only provides that the court can listen to disputes between citizens, going back to Article 3, Section 2, between citizens of different states, between citizens of the same state, claiming lands and grants of different states, that concept there of citizen, if that is the jurisdiction of the court, then the court has to reconcile its own constitutionality, right? We saw that in Marbury v. Madison, right? The court says, wait a second, we've only been granted this much jurisdiction. If we take more jurisdiction, we're going to be acting outside the Constitution. The Constitution is supreme, therefore we're going to follow the Constitution rather than a federal law. So here, in this case, we're asking the same question. That's the question before the court. That's what we have to think through right now, is whether property, descendants of African Americans that would not have any kind of legal standing across the United States, if they were slaves because they're property, whether they have standing to bring a case before the court. So, now we know the issue. Let's get down to this sub-issue here. So sub-issue is basically, okay, we need to know whether they have standing. And so then how do we determine if they have standing? It's whether, sub-issue, in order for the court to have jurisdiction, then Mr. Scott has to be a citizen. If Mr. Scott is determined to be a citizen of the United States, then he would have standing. Why? That's what's provided in the Constitution. If he's not determined to be a citizen of the United States, then there is no standing. So that's the question now, is whether Mr. Scott, who's a black man, descendant from Africa, a slave or a former slave, depending on which side of that V you're on, whether he would be a citizen. So the court asks, can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizen, of which one of the rights is the privilege of suing in a court of the United States in the cases specified in the Constitution. Okay. So, short answer right now is the court's going to look at this and say, no, they do not have a right. They are not citizens. Therefore, there is no standing. Let's start pulling at that now. Let's go through the analysis, which is still lengthy to be sure, not as lengthy as the original case. This truncated version should hopefully still be accessible. And like always, if any questions, email me, let me know. Let's talk through it. I think it's a really important case to understand. But for our purposes, we just don't have all the time in the world, right, to dive into all of it. So, the court declared that African Americans, whether enslaved or freed, were not considered citizens under the United States Constitution. It argued that at the time of the Constitution's drafting, African Americans were viewed as inferior and not intended to be included as citizens. The court referred to its own historical analysis to support this interpretation and referenced state laws and precedent to support their claim. So here's the next highlighted section here. The question before us, whether the class of persons described in the plea and abatement compose a portion of this people and are constituent members of this sovereignty. We think they are not, and that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. So, what is their argument here? If I can edit this in real time. Oh, that's cool. What's their argument here? They are looking at. Well, sorry. Let me tee it up as a rule before I make the argument. The rule that they're looking to is the Constitution. This is their third thing. This is what they're going to rely upon to say, what do we do about this? Do people of African descent, black people, have any sort of right as citizens and therefore be entitled to the right to sue or use or access the courts of law? So they look to the Constitution and they think about the word citizen. And they basically think about, well, the framers back in the day when they were putting together this Constitution by no means would have thought of slaves or black people in general as citizens. It would have been an entirely different class, a inferior class. There's several adjectives that the court uses throughout, but for our purposes, they are not thinking of black people as the same regard as white citizens. Why? They situate themselves in a historical analysis, and they generally look to the Declaration of Independence, which we'll jump to in a second, as well as some other state laws involving African Americans to say, hey, look, guys, at the time that the Constitution was written, this is the way that the framers thought about people of a different skin color than ours. The framers thought about a general class of people from African descent or otherwise, non-European descent or non-white, as an inferior class. Therefore, when we're looking at the Constitution and we're looking at the framers' intent of the Constitution, what do the words actually mean at the time they were written? By no means. Right? It says, on the contrary, they were at that time considered as a subordinate, an inferior class of beings who had been subjugated by the dominant race, and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power of the government might choose to grant them. It is not the providence... Actually, let me put a pause right there. That's tough. That's tough to read. It's extremely discouraging to read that there is this concept of superior races, inferior races, and even if a black person was emancipated, freed, they would still be subjected and subjugated to the rights and privileges of the quote-unquote superior class. That's a hard concept to reconcile with, but it's said passively, as though that is just what we're operating under. That is just our agreement of what is true and what is right based on the framers' intent of the Constitution. So now, what do we do about that, right? What do we start? How do we start unraveling that? Well, let's start kind of twisting or looking at this from another perspective as well, because the court's going to go on for several more pages. But for the purposes of this lecture, let's start looking more at this holding and this conclusion. So they say it's not the providence or the province of the court to decide upon the justice or injustice, the policy or impolicy of these laws. The decision of that question belongs to the political or lawmaking power, right? The legislative branch. We're just here to say what the law is. Remember, that's all the judiciary says they're going to do. We just say what the law is. To those who form the sovereignty and frame the Constitution, the duty of this court is to interpret the instrument they have framed with the best lights we can obtain on the subject, and to administer it as we find it, according to its true intent and meaning when it was adopted. It's not a bad argument. That argument we'll see play throughout. When we get to the Constitution, we want to know what the framers had in mind when they wrote it. We don't want this thing growing legs, sprouting arms, and walking in any direction that we may be in as a society right now. We want consistency. We want to be able to say, this is our Constitution, and this is how we're going to follow the Constitution based on what the framers had in mind when they put it together, right? When they framed our entire government, when they put together the three different branches, when they had certain understandings of God-given rights, inalienable rights. When we have that sort of understanding in mind, that's the way we should approach the Constitution. They make the same argument here. It's the same argument, except they get on the side of the equation where people that descended from Africa, African Americans or just non-European, really inferior race, whatever that may be, are not citizens. They were not intended to be citizens, and therefore they do not have standing to sue. So since African Americans were not recognized as citizens, the court concluded that they lacked the legal standing or right to sue in federal court. The court asserted that only citizens could bring lawsuits in federal courts, and therefore Dred Scott, as an African American, did not have the ability to seek legal recourse for his freedom. So this is another important concept in the law. Subject matter jurisdiction. So what can the court actually hear? What sort of subjects can the court listen to, reconcile, adjudicate? So subject matter jurisdiction is usually split between diversity jurisdiction and federal question. So in our case here, we're looking at diversity jurisdiction. The United States Constitution, Article 3, Section 2, grants Congress the power to permit federal courts to hear diversity cases through legislation authorizing such jurisdiction. That's the way it's set up now, and it's with us because of Article 3, Section 2. The provision was included because the framers of the Constitution were concerned that when a case is filed in one state and it involves parties from the state in another state, the state court might be biased toward the party from its own state. We talked about that in the last case, right? Texas, Oklahoma are fighting about their border. Let's say, for example, we don't want that case to go to Oklahoma. We don't want that case to go to Texas. We want there to be a federal level that can go to resolve amicably and fairly, unbiased. What that means, though, is that there are other implications of diversity jurisdiction, namely that it has to be between citizens of the United States. So if you have non-citizens, if you have people from other countries that have a dispute, they're not going to come to the American courts to figure out how to resolve this issue, right? They have their own legal system, whatever that may look like, whatever it may be. But the United States courts, the federal court, is specifically designed for citizens of its country. So that's subject matter jurisdiction. When we have a federal question, that's when it pertains to a federal law or pertains to the Constitution. Then sure, courts absolutely have the right or the power to the jurisdiction. Thank you, that's the word. The jurisdiction to analyze and adjudicate those sort of questions. But in our case here, we're looking at it like a state law. This concept that if you're south of that line, slavery is recognized and protected. If you're north of that line, it's not recognized. So what happens when you have a citizen of one state, or excuse me, a slave of one state go into those northern states where it's not recognized? Then surely his status would change. Once free, always free. Therefore, I'm a free man. So I'm going to sue for my freedom. Well, the court looks at this and says, wait a second, this guy's not even a citizen, so he can't sue in our courts. Case dismissed. That's the way it should be. We don't have jurisdiction here. They wash their hands of it and they walk on. Court doesn't do that. Court does not do that. They actually go a step further and start getting into more of the property rights, the property right dispute within this case. So I'm going to jump down for a little bit. There's the Declaration of Independence, justification for why apparently when it says all men were created equal, that doesn't pertain to all men. So worth reading on that, double clicking there. Let me keep scrolling. Okay, so this court starts getting into the property right issue that the Missouri Compromise proposed. Let me put it that way. So we know that the holding here, they say Dred Scott was not a citizen of Missouri within the meaning of the Constitution, so he's not entitled to sue in the courts. And so now that should be it. That should be the end of the opinion. That's it. We don't have jurisdiction. Sorry, guys, you got to go resolve your dispute somewhere else. But they don't. They keep going. And they make this argument here of whether, they ask a question, the next issue here, of whether the Missouri Compromise is even constitutional. And I think how much time do we have left? Okay, hopefully I can do this justice. It's not as important. It's important for the dissents to point what the court is doing right now. But for our purposes, basic argument here is that property owners have a right to their property, and in the Fifth Amendment says that no person shall be deprived of life, liberty, or property without due process of law. So the court is now taking it a step further and saying, wait a second, we have the ability to adjudicate whether a given law is constitutional within the confines of the Constitution. Here's the Missouri Compromise that would effectually allow this sort of situation to occur, namely when a slave goes from a slave state to a free state and becomes a free man. Well, the court reasons that's depriving the property owner of his property without due process of law. So they're going to try to strike down this case, even though it's not even on for debate. They just take it upon themselves to step out of the way and say, you know what, while we're talking about slavery and we're talking about standing and property rights, let's just go ahead and get into the thick of things with the Missouri Compromise. So they say, yeah, I can't dive into that right now. I'd love to. It's tough to read. It is tough to read, but I'd still encourage you to read it. It's in here with regard to how the court is reconciling this right now. So let me jump back up to my notes. Always good to stay on script. Okay, so yeah, in the courts of judgment, this would constitute the government depriving slave owners of their property since slaves were legally the property of their owners without due process of law, which is forbidden under the Fifth Amendment. So Taney, the justice writing this opinion, also reasoned that the Constitution and the Bill of Rights implicitly precluded any possibility of constitutional rights for black African slaves and their descendants. The court's ruling that the property rights of slave owners were protected by the Fifth Amendment, thereby allowing them to bring slaves into Indian territory. So this whole argument that Mr. Scott is making, which it should be a solid argument, there's laws that recognize me as a slave in these states. I go up to these northern states. I'm no longer a slave. I can't just all of a sudden become a slave again. I'm a free man. Once free, always free. He makes that argument, and the court takes it upon themselves to say, no. Actually, this law that you're relying on to say that you're a free man is actually inhibiting and depriving slave owners of their property rights. So actually, we're going to go ahead and try to strike this law down without really any reason to do so. And so one of the dissenting opinions, really both, but Justice McLean in his lengthy dissenting opinion points this out and says, wait a second, guys, this wasn't even an issue. This wasn't even an issue before the court. We only had to ask whether there was standing for Mr. Scott to promulgate his case through our courts, whether we had jurisdiction to oversee this. We got to that, wrongly, he'll say, but we still got to that. And now you're going on this whole tangent about whether property rights are infringed by virtue of the Missouri Compromise and some other laws. That doesn't make any sense. We're not here to discuss that. So the court, another good legal theory here, needs to stay within the confines of the issue presented. Otherwise, it's mere obiter dicta. I think I'm going to say that right. Good Latin phrase for Latin folks out there to know. But it means other things said or said in passing. My wife will say sometimes to me that I'm just talking to be talking. I want to hear my own voice. Judges have this platform. again, it's situated in the context of the United States is crumbling. It is having this huge contentious debate over whether slavery should be allowed or protected, whether people are entitled to certain rights that are granted to other citizens. And so the court has this huge platform to decide this monumental issue of whether African Americans are in fact citizens of the United States, regardless of whether they're slaves or not. If African Americans, even in these northern states, are citizens, and they say, no, they're not. That's not what the framers had in mind. So no, they're not citizens. No, they don't have the protections offered by our laws in the United States. And moreover, this whole Missouri Compromise thing, it was supposed to help kind of pacify the tensions and say, you know what, one for one, slave state, free state, free state, slave state. That's fun to say. No, that deprives slave owners of their property rights, and so we're going to go and attack that. So Justice McLean here, let me scroll down to him real quick, put it in green, kind of separate it. The dissenting opinion to dissent, of course, just disagree, and we're going to state our reasons for disagreeing, pointed out this obiter dicta and said, wait a second, we're not even here to talk about this thing. So only the holding that, scroll back up to it, Dred Scott was not a citizen of Missouri within the meaning of the Constitution of the United States and not entitled to sue in this court. Only that applies. That's what his kind of basic premise is here. Whether he agrees with that holding or not is really beside the point. Just looking at the analysis, where we can't go off on any sort of tangents here and promulgate this obiter dicta. That's not holding. It may be persuasive. It may be good reasoning, but it's not going to be law. It's not going to be stating what the law is. So like I said, I cut much of these dissents. When there's these ellipses right here, that just shows that there's more to it. I did my best just to kind of get to the heart of his arguments, which I'll cover here briefly because we are quickly running out of time. Okay, so Justice McLean's dissent argued that the court should have refrained from deciding the broader issues of citizenship and the constitutionality of the Missouri Compromise, as they were not necessary to adjudicate the case. Again, the only little issue there is whether the court even had jurisdiction, whether Mr. Scott had standing to sue his master for his freedom. McLean believed that African Americans, whether legally brought into a free state or territory, should be considered free individuals, and their status should not revert to that of slaves when returning to a slave state. He criticized the majority for perpetuating inequality and undermining the principles of the Declaration of Independence and the rights of all individuals. So, dissent, definitely worth reading. This is a great quote. You may have seen this from other places. It is true. This was said by the court, as also many other things which are of no authority. Nothing that has been said by them which has not a direct bearing on the jurisdiction of the court against which they decided can be considered as authority. Again, obiter dicta, you're just talking to be talking, has nothing to do with stating what the law is. I shall certainly not regard it as such. The question of jurisdiction being before the court was decided by them authoritatively, but nothing beyond that question. So as soon as you get past that jurisdictional question, all this other stuff, obiter dicta, we shouldn't have to even consider it. Why are we going that far above and beyond when that's not even the question presented to the court? And this is the line. A slave is not a mere chattel. It's not just property. He bears the impress of his maker and is amenable to the laws of God and man. And he is destined to an endless existence. The Imago Dei, right? He's saying this isn't property. This isn't like a horse. This isn't like a dog. This isn't like furniture. This is a human created in the image of God and deserves all the rights accordingly. I think that's probably the best argument to be made. All the legal procedural stuff, those guys have to go do that. When we're thinking about this case and we answer these questions here this week to start pulling out these larger implications from the reasoning and analysis within this case, I hope that sits in the back of your mind of how, right? How can anyone look upon another human and not see the image of God? How can they perceive that this person is anything but a human, a person deserving the full protection of the law? Okay, Justice Curtis' dissenting opinion. So Justice Curtis argued that Dred Scott had the right to sue and should be granted his freedom. He emphasized that the question of Dred Scott's citizenship was not relevant to the case because the court has jurisdiction over cases involving citizens of different states. Curtis contended that the majority's interpretation of the Constitution was flawed and inconsistent with its original intent. He maintained that African Americans, regardless of slave-free status, were indeed citizens and entitled to the protection of their rights under the law. He points out that there were 5 out of 13 states at the time the Constitution was ratified that recognized the citizenship of black men by virtue of allowing them to vote in the state. And, of course, by extension, any citizen of a state would necessarily have to be a citizen of the United States. You can't be a citizen of a state without being a citizen of the United States. So this whole framers' intent concept is just woefully misplaced. A piecemeal argument, to be sure. They cite plenty of examples to show at least support in a sort of reasonable fashion their conclusion and claim that the framers would not have intended this. But it's not like we had the framers here to ask them, hey guys, what did you think about this? What would you think about this? We kind of in our modern perspective have to look back and look for evidence surrounding the time period to come up with this framers intent argument. Sometimes it's good, sometimes it's bad, but that's why it's important for us to recognize that's a foundational component of law. When laws are written, especially the Constitution, that is a whole school of thought of how to approach certain laws. Is what did the framers actually have in mind? When they put pen to paper, what were they thinking of? So it's easy for us in our sort of modern notion to put on our modern goggles and look at the law and try to interpret things according to our popular opinion. Whether that's good or just or right is a widely contested issue. Some people believe that Constitution should be more of a living document. I should be able to speak to today's times, even though it was written, 200 so years ago. I'm going to do the math. Almost there. Almost 250. So with that being said, is the Justice Curtis here makes that argument of, wait a second, if we're going to look at the context in which this was written in, what are you going to do about these other states that have rights granted to black men that would necessarily confer them citizenship within their own state and the United States? And then finally, he also criticized the majority for venturing beyond the scope of the case, addressing constitutional questions that were not necessary to resolve the Dred Scott claim for freedom. Okay, so let me scroll through the bottom real quick. Okay, so that's the case. Super famous decision for a lot of the wrong reasons. Largely considered a bad case, not only for its conclusion, but for its reasoning. That requires more scholarship. If you are truly interested in that, you may have the opportunity in college or in law school perhaps to dive into this case deeper. You can do it on your own time. You can definitely find the whole copy of the case, the 200 some odd pages, to look at that and start reconciling that reasoning. How did we go so far off the tracks? It's easy in our modern minds to kind of cringe when we read some of these paragraphs, but these were extremely well-educated men. How did they go so wrong? Well, that's part of it, is their reasoning was not right or good or just or whatever kind of adjective we need to put in there. The other aspect of this case, this holding that was passed down, is that it also catalyzed much of the ongoing tension between the states. So all of a sudden there wasn't so much of a balance, right? The compromise, whether there was actually a balance or not, is perhaps beside the point. But it all of a sudden said, wait a second, any African Americans within this country are not citizens. I don't care if you're currently a slave, formerly a slave, never been a slave. If you're of African descent, not a citizen of the United States. So that fanned the flames. By all means, people are not content with this holding. Some, of course, would be. No doubt about that. It's a civil war for a reason. And then kind of fast forward, getting through Civil War history at this point. 13th Amendment, 1865. So this was 1857, 1865. The 13th Amendment abolished slavery and involuntary servitude throughout the United States and effectually nullified the legal basis for the Dred Scott decision, declaring that no person could be held as a slave or subjected to forced labor. And also the 14th Amendment, which is 1868. 14th Amendment addressed the status and rights of African Americans, including those who had previously been enslaved. It defined citizenship and granted equal protection under the law to all persons born or naturalized in the United States, including former slaves. And this amendment aimed to secure civil rights and due process for all citizens, regardless of race or ethnicity. So, we'll be able to reflect on this case more. The next discussion, certainly through the questions that will be assigned this week. Questions, as always, please let me know. Happy to discuss this further with you as needed. I think kind of zooming back out now, kind of taking that 10,000 foot view of this case, it may still not make sense. It really might. You may read through this case and just think to yourself, this just isn't clicking. And this was the Supreme Court. How are we supposed to trust anything that comes out of the Supreme Court? It's a good question, and I think it's worth reconciling with. It's not something that I can necessarily give to you. There's not necessarily an answer to hand over to you, but it may very well be something that you wrestle with yourself. I know that when I still, reading this case to prepare for this lecture, same thing. And I've read hundreds of legal opinions at this point, and so that question definitely sits in my mind. I think the other point to recognize, too, is that this was a extremely difficult time in our country's history. So when we, again, have to set up the historical context of what was going on, it's not like these judges were living in a vacuum, just, pure rational thought, and were able to, parse through and arrive at a perfectly reasonable conclusion. They are influenced by the political body in which they belong. So that will also be seen in several other opinions that we'll read through this semester as well. But for our purposes now, it's worth knowing that we're infallible. We are prone to fallacy, I should say. We are not perfect. By no stretch of the imagination are the people that run the country, right, that sit on the bench, that are the best of the best with regards to a legal mind. By no means are they perfect in every single holding, but neither are we. So when we do approach this case, I think it's really important to read it in the historical context. I think it's really important to reconcile and wrestle with these arguments and try to understand if we were situated in this historical context, how would we also respond to these ongoing debates? What kind of biases and prejudices would come to bear within our reasoning, and see how that could cloud our judgment and our mind. And most importantly, I think it should also get back to the fact that that this is a shadow, right? This is a shadow of the good things to come. So try and strive as we might to achieve justice, righteousness, to speak truth within the law. We'll get it wrong. We will get it wrong more times than not, and it's tough to recognize what we could be going wrong in today's time. So some things are more obvious than others, of course, but some things aren't. And so recognizing the historical context, recognizing the reasoning and how the historical context can cloud that judgment, I think is very important. But all to be said, 13th, 14th Amendment comes along. This is no longer law. This case is cited not for its legal holdings, not cited as precedent, but by all means of what went terribly and horribly wrong. So any questions, please email me. Wrestle with the case, wrestle with the reasoning, get through the questions. Hopefully it'll help tease out some more of these themes and concepts within the case. And pray that it blesses you and have a blessed week. I'll see you next time. Take care.